4th, 8th,
and 9th respondents, Your Honor, and their parents. We wish to stand in solidarity with the victims of this sad incident, and Kenyans at large, and convey very sincere condolences to the families, relatives, friends, and neighbors of the 19 children who lost their lives.
the figure again? You have added 3 others.
So there were reports filtering this morning.
Okay.
We are totally clear to have been more
So it's not a mistake.
Yes, it is not a mistake.
Of the 19
Children who may have lost their lives
students.
because of the inferno that raised to the school, Your Honor.
Go on, Kipach.
We also wish the many children who are undergoing treatment the quickest of recovery. And my clients and their families stand with them during these very difficult times, Your Honor. We similarly thank the court in the manner in which it has conducted these proceedings involving minors so far. And even the manner in which the prosecution supplied us with the application in good time, Your Honor. It was very professional of my colleagues from the ODPP with the investigating officer. So that if you permit me, Your Honor, I will now proceed to the meat of the matter.
Please do.
Your Honor, you are invited by the prosecution to detain the respondents for 30 days. Your Honor, is about, it's more than 4 weeks. Ordinarily, this court is empowered under Article 49, 1H to admit the respondents to bond or cash bail, whether the investigations have been completed or not. And Your Honor, there is only one issue that should engage the mind of the court as to whether a suspect should be released on bond or not. And that is one reason, Your Honor. The absence or presence of a compelling reason very amply, Your Honor, we submit that the prosecution has not established a compelling reason Your Honor, you've been told that there are a multi-agency operation. This could be true. What Your Honor has not been informed sufficiently is what would be the role of these children in the ordinary operations of the DCI, for example. Can they interfere with the government chemist? Can the children interfere with the Ministry of Public Works? And the answer, Your Honor, is that it's not possible for these children to interfere with these government agencies. You are told that there are many children released after the closure of the school. The correct number is 800 children. How can 9 children, Your Honor, shooting into the dark because we don't know how many of them are witnesses, where they live in, where there are homes? Do these suspects have their contacts? Like my colleague Mr. Mogira said, that suggestion that these 9 suspects could interfere with 800 girls out there in Wajir, in Homa Bay, in Tiati, can be interfered with. It's not just a timid suggestion. It is a wishy-washy suggestion, Your Honor. It will not derive a compelling reason. The right treatment for public outrage is the rule of law, constitutionalism, and the due process. Justice will not be served through the trial detention the victims, we respectfully submit, Your Honor, will not get justice through pre-charge detention of 30 days. What happens when they come after 30 days and say we are dropping 5, 6, or all of them? They shall not take plea because there is insufficient evidence. Because they would have been detained through a court order, they would have no compensation for violation of their right to liberty, Your Honor. This being a senior court, and a very fair court. Please take note, Your Honor, that public outrage is an unruly horse. It should be served with what the Constitution provides and the rule of law, not through pre-trial detention or pre-charge detention. If you permit me, Your Honor, I will accompany my submissions with two decisions. I have shared, unfortunately I didn't bring hard copies, but I have shared one decision with Madam Okok through WhatsApp. This is a High Court decision which is reported. This is the case of, I've also shared with Mr. Wairudi, who has already read it, the case of Oscar Kipchumba versus Republic, Kenya Law Reports Electronic. And
Which year?
this is 2020, Your Honor. And I'll read a copy after this. And Professor Joel Ngugi, as he then was, considered similar issues: security of the suspect, and the Honor, the court made it very clear that it is the responsibility of the security apparatus of this country to secure suspects, secure witnesses, and they can't use that as a compelling reason to deny bond. I had already invited Your Honor to dismiss the wishy-washy application on interference with witnesses. This issue also of suspects being harmed by undisclosed members of the public is not a compelling reason. In any event, remand institutions are not meant to provide securities for people who are under threat. They hold people who are going through trial. The suspects here are not going through trial. Investigations have not been completed. It's only the IO who thinks that they might go through the process of trial or murder and or arson. Is that for Your Honor? Underwhelming to suggest that you use the issue of want of security as a compelling reason. The parents are here. They are committed to take care of their children as parents, involve counselors where necessary, and ensure they are in court as and when required. At paragraph 24 of that decision by Justice Joel Maura Ngoge, as he then was, Your Honor, the court held that, I know Your Honor is studious and you would have an occasion to go through this. The court held that the state must persuade the court that it is acting in absolute good faith, and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Your Honor, there's nothing exceptional. These children have no access to DCI. They have no access to the government institutions or even the school. The school has been closed. They can't access the 800 children from Utumishi Girls Academy. Let the investigation run, grant these children bond and or cash bail. If they are supposed to, if the court directs the report every 2 weeks at the DCI in Nairobi, Naivasha, or Nakuru, the children will comply. Paragraph P again, Your Honor, of that, paragraph P of, clause B of paragraph 24. Your brother, Justice Ngugi, said that the state must demonstrate that this kind of pre-charge detention is the least restrictive action. Your Honor, you will have an occasion to look at this decision. I know you've read this decision at your level severally, and I would not want to rehash what the High Court said. That was Oscar Sudi, an ordinary, a member of parliament and an adult. When you look at Article 53, F of the Constitution, the options for detention now become very, very limited. There has to be an idiosyncratic reason, a very unique reason. None has been demonstrated, Your Honor. And finally, Your Honor.
Yes.
Section 4 of the Children's Act, which adopts the United Nations Convention on the Rights of the Child, guides this court to consider the best interests and welfare of the child, even under such circumstances. And in fact, Your Honor,
Yes.
under sections 186 and 187 of the Children's Act, which are very familiar to this court, detention of a child should be the last resort. What is then our ask, Your Honor, if you are persuaded not to allow this application? Our ask as respondents and parents, Your Honor, is that you strike a balance. Please admit these children to bond on such reasonable terms, Your Honor, as you may deem fit. The parents and the children will not interfere. They will not reach out to any other child or parent from Utumishi Girls Academy. They are willing to present themselves as and when required in any police station, as this honorable court may direct. And if push comes to shove, and they have to take plea, because that is the ultimate station in criminal proceedings, they are more than willing, Your Honor, to attend court and comply with such directions and orders as the court may direct. Your Honor, please decline this invitation to bring back the trial detention, pre-charge detention. Decline the invitation, Your Honor, and adopt a progressive approach where justice is served for victims, for suspects, and for the rule of law. Your Honor, you will, when you retire, you will consider this decision on children. This is JMK and 9 others. JMK and 9 others versus Republic. This is Kenya Law Reports 2014. Sorry, 2015. By Justice George Dulu, who emphasized the best interest of children, not just to grant bond, but to even review bond terms where children are struggling to meet the stringent bond terms as may be granted by court. Respectfully submitted, Your Honor. This is the decision. I have a hard copy.
And Section 4 of the Children's Act. On those...
1 second.
Yes,
See, 53F is of the Constitution, Section 223 of
the Children's Act and Section 4 of the Children's Act.
Go on.
Of importance to note that, Your Honor, in those sections that we referred to, as well as the provision of the Constitution, it seeks to address the question of the best interest of the child, which the defense, in their response to the application before you, they have sought to invite you to look at this application as being one that does not consider the best interest of the child. Therefore, the respondents before you. The prosecution, on the other hand, has advanced very clear and elaborate application supported with an affidavit of a chief inspector.
Yes.
To indicate and demonstrate clearly before this honorable court that the best interest of the child and the respondents for this particular case cannot be overemphasized, if not as it is contained in the application before you. As nobody can state that they are preserving the best interest of the respondents if we do not preserve their security and safety. And Your Honor, it's now in commonplace that best interest of the child may not be necessarily what interests the child. What the defense has advanced and requested you is most likely what will interest the respondent. You've been also, Your Honor, invited to consider the fact that the prosecution has not advanced any compelling reason to warrant this honorable court to consider pretrial detention. Your Honor, as you may know, the prosecution does not require to prove all available compelling reasons to warrant a court of law to consider pretrial detention. Your Honor, compelling reasons have been laid down by various decisions of superior courts. And one celebrated law as a classical of this particular area of law is the celebrated case of Republic versus Jackton Mayenne.
It's Joktan.
Jokton, sorry, Jokton. J-O.
Joktan Mayenne.
Correct. Your Honor, where the court clearly listed the compelling reasons.
2012?
Yes, it's 2012 for the citation. Where the court listed compelling reasons that the state can advance.
Your Honor, with tremendous respect.
Yes.
I think what my learned friend could do is only refer you the decision because they are in Kenya law reports, but he can't highlight at this time. We have already.
Yes, because I agree because you will not have the opportunity to distinguish. But it is.
Is it not incidental, Your Honor, because they raised the question of compelling reason, and this is contained in the application?
Let me hear him and then see whether because you raised the issue of whether you and Mr. Mugire both raised the issue of whether there are compelling reasons, and in fact you said, if I quote you, that the only consideration I need to make is whether there is compelling reason, which I agree with you fully. That is the constitutional threshold.
I stand there.
So now that he's raising it, and he has brought in the case of Joktan Mayende, I know why he's bringing it, because on several occasions I have had to deal with these matters before me here, and it's because in Joktan Mayende they lay down what juridically would be compelling reasons. You can actually Google it as we are going on, so that if there is a point where you may need to clarify, because the mere existence of case law does not necessarily mean that the application is allowed. It's just reflecting on what has been decided.
Yes, only of the view that he could, that's a part of the decision. Yes. Without going back to the facts.
He may not the facts. He may need to highlight what that decision is about. I think I cannot stop him from that because you raised the issue of compelling reason.
I stand by that.
Okay, thank you, Coach. Okay, proceed. Yes.
And in this decision, Your Honor, the court listed a number of compelling reasons, and what interests to me in the matter is the fact that the court addressed the question of the security and safety of the respondent. Your Honor, you've also been invited to look at the fact that the respondents are not a flight risk in the consideration of the response by the defense.
Yes.
And it is our submission that the application before you and the pretrial detention as it is now, that is the basis of this application, is not only just a functionality of a flight risk. in addressing the question of interference of witnesses, the defense has also invited you to the fact that the respondents have no means or ability to be able to interfere with the witnesses. However, Your Honor, counsel has also clearly demonstrated to you on behalf of the respondents that these particular students in this school, Utumishi, they live all over around the Republic of Kenya. And in showing that they cannot interfere with the witnesses, they have also not demonstrated that these particular students will not be neighbors to each other or known to each other, and therefore bring in the question of interference. The question of public outrage. Your Honor, the question of public outrage goes hand in hand with the safety. Goes hand in hand with the safety of the respondents. And therefore, Your Honor, the defense cannot invite the court to ignore the demonstration by the way this court is packed and so many people even outside there. The court can take even judicial notices on the fact that there is a clear public outcry that cannot be ignored just because during the trial of Jesus it was wrong and it led to a wrong finding. I don't know which tribunal such or that. The court can also even take judicial notice that there has been special arrangement in terms of security for this proceeding even to proceed today. If that does not mean anything in terms of what public outrage is, then definitely, Your Honor, I don't know any other possibility that can be able to convince any person properly directing their mind on this matter with regard to what public outrage is. Counsel has also averred to, in his response, has also referred to the question of the identity of the respondents having been concealed, both inside this court and even outside the court. And the reason the identities have been concealed before this court is known because it's a matter of public policy and the law that the identity of the minors appearing before a court must be concealed. But it will interest the court to know that that identity is not only concealed before this court, it has also been concealed even outside the court. And what counsels have not addressed you in their opposition to this application is that the reason for concealing the identity of the respondents outside this court is again to protect their safety.
Yes.
You've also been invited to look at what will be the role of the respondents in terms of the pendency of the investigation that the investigating officer is undertaking. And according to the defense, you've been informed that they have absolutely no role. That again, Your Honor, cannot be far from the truth. But then if the court is invited to take that approach, then the court will be invited to take a narrow approach instead of taking a holistic approach of the entire matter, which does not just rotate around the role or the involvement of the respondents before you, independency of the investigations. In the case of Oscar Sudi, which you've been invited to look at when you retire to consider this matter, I need not even re-emphasize that particular case because Council has done the work for me, and I will just simply add the cherry on it. Council has simply invited you to the fact that the court did not say that there should be no pre-trial detentions. In fact, reading of all that decision, you will be able to appraise yourself that the court was alive to the fact that there will be pre-trial detentions. And that's why the court said there has to be exceptional circumstances. If what we are faced with today is not an exceptional circumstance, where we are faced with a situation where 16 lives now, even with the update from the bar, we are now told we are at 19 lives, young lives which were lost. And the circumstances surrounding the complexity of the investigation in the matter, then it does not form exceptional circumstances to warrant us to come into the purview of what Professor Justice Ngugi was referring to in the case of Oscar Sudi. Then again, I do not know what exceptional circumstances should be. Again, that court in that matter referred to the question of restrictive, as detention to be a restrictive last resort. Again, it's our submission before this court that this is the last resort. Going by the facts and the grounds that have been laid out in the application by the investigating officer, we on the side of prosecution, we do submit that we have no other option. This is the last resort. That the respondent, in their own best interest, in the interest of the victims, and in the interest of these investigations, there has to be a pre-trial detention. Is that pre-trial detention in the best interest of the minors? Yes, it's in the best interest of the minors. We are not saying these minors be taken to a GK prison. We are saying they be taken to a remand home. Were the remand homes created for adults? The answer is no. They were created for children who are in conflict with the law, such as the respondents before you, as a last resort. Which again, Your Honor, we have submitted. This is the last resort.
Allegedly.
Allegedly. You've been invited by counsel to adopt a progressive approach in interpreting this application and in exercising your mind on this application. Again, we cannot agree more with that invitation. And what is progressive approach from where we sit? Progressive approach is to invite you to deviate from the normal. And how do you deviate from the normal? The normal will be what counsel had submitted to earlier, that you decline this application. Or you go by the approach advanced by my learned senior again, Kikwech, which I believe is drawn from the Solomonic wisdom of the split the child into two, so that both mothers can have some, where he has invited you in the event that we convince you, then give them bail and release them on board. We insist that the best interest of these respondents will not be served by them being admitted on bond, independence of these investigations. For those many remarks, Your Honor, we do submit that this application finds paper before this honorable court and be allowed as it is. I may allow my colleagues if they have any other thing that
I would want to be provided that so that as I retire to make my ruling, I'm aware about the ages. There was no submission with respect to the ages of the respondents, and I do not want to make them stand to tell me when they were born. But do you have Peter Kamau, which is you? Do you have the specific birth certificates or proof of birth, proof of ages?
yes,
You have all the proof of ages?
CBS and
The children department. So we have the ages. That documentation needs to be provided to the court. So this must be done. Martin, you will receive the documentation because I cannot tell them. I cannot tell that they are children without proof of age.
No, you actually under the impression that report from the children's office and everything.
Has it been availed? Is there a report that has been brought? Eh?
It ought to have one.
No. There is usually under different circumstances. Because there are too many eyes. Usually, I would ask the respondents how old they are and if there is any proof. But now, you see, if I do that, then I'll be infringing. I'll be going against my own regulations here, right? So, Khaimba, tuko na hizo documents.
Yes.
So, what you do, please avail them to Martin. Martin is my court assistant. So avail them so that then it can be of use to me, right? I intend to make this ruling as fast as possible, so I'll make it tomorrow at 2 p.m. Tomorrow at 2 p.m. Where do we hold them today? Where they have come from? Yes, I do not know where they have come from, but where they have come from, and I'm sure Mr. Kikwej, we are certain now that with the children's office that they are in good hands, that there is no possibility of being held with others.
That is what we are fighting for, because I come from Nakuru and I know what they are talking about Nakuru children.
No, it's not about Nakuru children's home, where they have come from today.
That is in order. One request, Your Honor, that I would make is they be allowed to access the 3 respondents that I represent.
Let me inquire. Is there any objection to that? Is there any objection to the council accessing the children? Let me get it from both the IO or the IO. Any objection from or the PP first?
We have no objection.
You have no objection. Only the council, eh?
For the council.
Council, you can access. Council, you will be able to access, and through Mr. Nyuguto. Mr. Nyuguto is here together with Chief Inspector Kamau.
Thank you.
So you both have access. I'm actually going to put that on record.
Thank you.
Okay. So that now I'll deliver ruling at 2 p.m. tomorrow. 2 p.m.
We are
Okay.
marching that.
Okay. I'll deliver it. It will be physical because they must appear in court. All right. Or do you want us to do it online? Okay. So we do it in person. All right. So Father, so Kipkoech, I seek order that council be allowed access the respondent. So Ms. Bosire, no objection. Ruling at 2 p.m. on 3rd of June 2026. All right. And I think we are done. Now, I would like that we clear the court, all right? So that I am still having other matters. The media has no problem if you can start reporting about tuko na plea za pombe tuko na plea pombe na nini. We have our usual business here in Naivasha still going. Okay, so we can reorganize the court. That's okay. Martin, you put those documents.
Tunaenda